from the Ford Foundation.
Good evening. Tonight's landmark case is 1965's Griswold versus Connecticut. With a 7-2 decision, the justices in this case established a constitutional right to privacy and set in motion expansion of privacy rights that continue to today over the next several decades. To give you a sense of Griswold's continuing importance in our society, we put together a short video that is modern-day references to the Griswold case. Let's watch.
Griswold v. Connecticut, which recognized a right to privacy in the Constitution.
I agree with the Griswold court's conclusion that marital privacy extends to contraception and the availability of that.
Griswold versus Connecticut.
Griswold versus Connecticut.
Back in the 60s, there was a case known as Griswold versus Connecticut.
The holding in Griswold.
Let's talk a little bit about Griswold.
Griswold talked about emanations and penumbras.
What is it about Griswold versus Connecticut that gives it its lasting importance? We're going to learn about it and the history of this case and the interesting people involved with the table for the next 90 minutes. Helen Alvarez is a law professor at George Mason University's Antonin Scalia Law School. She is the author of numerous books on family law. Her latest is called Putting Children's Interests First. Rachel Reboucher is a law professor and associate dean for research at Temple University in Philadelphia, co-author of a book called Governance, Feminism, an Introduction. So let me just ask the basic question, why is Griswold so important?
Well, Griswold was a landmark case when it was decided in '65, 5 years after the birth control pill, hit U.S. markets. It's a landmark case now because it set the path for cases deciding abortion rights, sexuality, sexual expression, same-sex marriage. It also, in '65 and now, is a warning to states about how to use the criminal justice system to police people's most intimate, fundamental decisions.
And what are your thoughts on the landmark nature of this case?
Yes, it's a declaration of a right of privacy, which is not in the text of the Constitution, and all of the justices' discussion of is it safe for judges to be finding rights that are deemed fundamental, very important liberty rights, that are not in the text of the Constitution? How do we find these? How far do we go? And it set the path, as Rachel said, for all the later decisions on sexual expression and marriage based on that finding of privacy.
Is there a conservative consensus about Griswold?
No. I would say there are many people who, citing a couple of the cases Griswold cited, the right of parents to decide about where they're sending their kids to school, parents deciding about kids' education. A lot of conservatives would say, yes, those rights exist. Some would say it's always dangerous when 5 unelected justices or more discover a right that's not in the text of the Constitution. How far will they go?
Is there a liberal point of view that encapsulates Griswold?
That Griswold tied the right to birth control, the right to contraceptive use, to a broader agenda for reproductive rights. And over the years, since 1965, that agenda has been more closely associated with the women's rights movement and with feminism and with women's equality in education, politics, and the workplace. Is that a consensus? I'm not sure it's a consensus, but I think when you ask most who think of themselves as progressives, their take on why Griswold's important, they would come up with some of those reasons.
Well, I mentioned there was an interesting cast of characters for this case. The namesake is Estelle Griswold. And Helen, who was she?
So Estelle Griswold is a woman who has a very serious interest in the availability of contraception. She is married to someone in the State Department. She ends up doing some international work in this area, and she decides that Connecticut's law is old-fashioned and needs to be done away with, and she decides to form a clinic and to deliberately violate the law and get before the court and get this Connecticut statute looked at once and for all.
We're also going to meet Dr. C. Lee Buxton. Who was he?
Charles Lee Buxton was the chair of Yale's OBGYN department, the only medical school at the time that Griswold was decided in the state. And he, with Estelle Griswold, came up with the strategy, the test case that would become Griswold versus Connecticut, to strike down the ban on contraceptive use for married people. He felt a personal responsibility to the patients he saw suffering with pregnancy complications who couldn't access legal contraceptives in the state.
There's a female lawyer we're going to learn about named Katie Rohrbach. Who was she?
She is a real figure in history, right? I think she was the only woman in her class when she graduated from Yale Law School. She was associated with a number of really significant lawsuits, including not only this case, which she worked on through the Supreme Court. She didn't actually do the arguing in front of the justices, but she took it up to the Connecticut Supreme Court. She was later associated with defense of the Black Panthers. She felt very strongly about women's rights and about access to contraception among those.
And our last cast of characters before we get to the justices later on is Thomas Emerson.
Emerson argued the case for the Griswold legal team before the Supreme Court. He was a Yale law professor who took over from Fowler Harper, one of the original engineers of the test litigation, when Professor Harper fell sick.
You were both talking before the program started about the Yale connection. So many aspects of this case seem to intersect with Yale. Is it just a coincidence?
Well, it wasn't Connecticut, and Yale has been a preeminent law school for a great deal of time. And probably you could say known at that time and now, although I'm not a historian of Yale, for being unafraid to do controversial things, and this was indeed controversial. You have Griswold is married to someone from Yale. You have Dr. Buxton, who is on the faculty at Yale. Emerson is on the faculty of Yale. Rohrbach, she had family who was at Yale. She also graduated from Yale, so quite a few links.
And so also, apparently, Estelle Griswold made a mean martini and had cocktail parties at which they would gather. And it was over one cocktail party that they came up with the strategy for one of the early cases that preceded Griswold. So there's that.
Never underestimate the power of social connections, right. So this was referred to as a Comstock law. Can you give us a quick history of Comstock laws?
So the federal Comstock law is passed in 1873. It's named after Anthony Comstock, who is a postal worker but also founds the New York Society for the Suppression of Vice. At some point, he famously brags that he has confiscated 160,000 pounds of books, 95,000 articles, and 60,000 implements of rubber for immoral purposes. Not my quote, his, but he lobbies Congress for the Comstock Law, which makes it a crime to mail obscene materials, contraceptives being an obscene material, to mail them, to mail information about them, to mail information about how to find out about contraceptives. So that's the Comstock Law.
This is 1873 when the Comstock laws were passed. We're talking about a case from 1960, 61. Right. Was it were Comstock laws on the books in a lot of states by this point?
Almost half the states in the country. I think it was around 24 states. So, and considering that some states came in later, so more than half at the time. I think Connecticut's goes on the books in about 1879. Fascinatingly, the state representative who was its primary backer is P.T. Barnum, yes, of Barnum and Bailey Circus. And that law stays on the books through to the time of this case. by the time this case comes around, really only Connecticut and Massachusetts have these laws on the books. Connecticut's law, the federal law was really concerned with mailing these. Connecticut's law is concerned with the people who use them, including, banning them in marriage, and concerned with people who aid and abet them. That would be usually the medical authorities.
In about 10 minutes, we're going to go to your phone calls and involve you in the discussion. We look forward to your comments by phone, 202-748-8900 if you live in the Eastern or Central time zones, 202-748-8901 if you're in the Mountain or Pacific time zones. You can also send us a tweet. Use the hashtag landmark cases. There is a discussion underway on C-SPAN's Facebook page, if that's your primary means of connecting socially, and you can join the conversation there. So please do get involved in this discussion on Griswold versus Connecticut, which established the right to privacy not enumerated in the Constitution. Some of the text of the Connecticut law read this way: and any person who uses any drug, medicinal article, or instrument for the purpose of preventing contraception shall be fined not less than $50 or imprisoned not less than 60 days nor more than a year, or be both fined and imprisoned. In reality, by 1960, how often was this law enforced in Connecticut? Were people getting arrested for it?
It's hard to arrest someone for the use of contraceptives. So that's where the part of the statute that made it a crime to aid and abet was really important. And by and large, people were not getting arrested. Condoms, spermicide was available in drugstores. It was available, though, for the purpose of disease prevention or feminine hygiene. So as long as you sold a contraceptive device or a contraceptive drug for other than contraceptive reasons, it was legal. Of course, that didn't include the diaphragm or the pill. So those are still hard to come by. Were people getting prosecuted? No, although an early case in 1940, a clinic was raided. The nurses and doctors were prosecuted, State versus Nelson. They went before the Connecticut Supreme Court of Errors, and they lost. The Connecticut Supreme Court of Errors said there are no exceptions, not even for doctors' prescriptions. These doctors had been told by a local attorney that writing prescriptions would be an exception to the law based on other cases in other states. And the Supreme Court of Errors held that that was not the case, and there were no exceptions to the Connecticut law.
But it was not referred to or taken up by the Supreme Court at that point?
No, that State versus Nelson was not appealed to the Supreme Court.
There were earlier federal efforts to overturn Connecticut's Comstock law, Tyleson versus Ullman in 1943, and then Poe versus Ullman in 1961, very close to the time of our landmark case tonight. What was happening with these cases?
Right. In the Tyleson case, it was a doctor trying to argue that the patient's life was at stake. And the court said, I'm sorry, you don't have standing to assert your patient's interest. In Poe versus Ullman, which happens in 1961, they won a declaratory judgment that this law could be enforced against them. And the court says, it's not ripe. There's not a controversy. Nobody's been arrested. Nobody's been convicted. And so it's just not ripe yet. But if you look at Poe versus Ullman, the dissents from Douglas and Harlan, you have yourself Griswold in miniature. And if you can track so much of the language from the dissents in that case that said it's ripe, and by the way, here's how I would decide it if it came before me.
And we have a regular viewer of our series, Wild and Wonderful on Twitter, who writes, the penal aspects of the Comstock laws are rather ironic, insofar as a stint in prison is another way to prevent contraception.
Clever.
So we get to 1961. Here's a headline in the New York Times: Connecticut clinic to test birth control law. So there were a group of people in Connecticut who decided they wanted to put this law to rest. And what was the role of Planned Parenthood organization in this?
Well, Planned Parenthood, led by Estelle Griswold, in Poe, the 61 case, had recruited the 3 patients that would become the petitioners, led by Dr. Buxton, Dr. Buxton's patients. And she was instrumental in helping Dr. Buxton find those patients and decide on that strategy. Planned Parenthood then was instrumental in figuring out that once Poe, once the Supreme Court dismissed the appeal from Poe, because of lack of prosecution, no credible threat of prosecution. It was Planned Parenthood that was the engineer of a strategy to set up a clinic so that the director and the medical director could get arrested to test the Connecticut law.
So Planned Parenthood was operating around the state at this point?
Estelle Griswold had explicitly set up a Planned Parenthood there. They had been in other areas of the state. I think they'd been in Hartford and New Haven.
Well, so they had actually a number of clinics that were operating throughout the state. And then the case that I mentioned, State versus Nelson, they all closed after that case. And then they started setting up clinics for educational purposes and to lobby the legislature. Yes. But the New Haven clinic at issue in Griswold is the clinic that started prescribing contraceptives. Before that, other clinics and other places were just doing educational, other services that weren't banned by the law. Although Estelle Griswold reportedly drove around the state with diaphragms in her car trunk, as well as Planned Parenthood was key in helping women get across state lines so they could seek contraceptives legally in other jurisdictions.
We've got some video, some film actually, from 1962 when CBS Network did a report on the Connecticut birth control debate. And what's great about this is you're going to see Dr. Lee Buxton and Estelle Griswold in their own words describing how they put this test case together.
Dr. Buxton, how did you become involved in this birth control case?
Well, I am interested in taking care of patients in this institution. And when I'm prevented from taking care of patients the way they should be taken care of by a law that exists, I just happen to believe something ought to be done about it.
Well, aren't people who want birth control information getting it in this state?
If a woman can afford to go to a private doctor as a private patient and pay a fee, she can get contraceptive advice in Connecticut. But if she hasn't the money to go to a private doctor, if she's a patient in our clinic here, for instance, she can't get contraceptive advice here because we're not allowed to have a family planning clinic. And they're the ones that really need contraceptive advice from a socioeconomic as well as from a health point of view. And they're being discriminated against because of their economic status.
Well, since, as you said, that many people who can afford to go to a private physician can get contraceptive information, how many people would you say there are in the state of Connecticut who are breaking the law every day?
Connecticut has one of the lowest birth rates of any state in the United States. Now, you can't tell me that that's because they're carrying out either Puritan or Catholic ideals.
Mrs. Estelle Griswold, the other defendant, is executive director of the New Haven Birth Control Clinic.
Well, I think it's very evident that the law is unenforceable. I think if you had a policeman under every bed in the state of Connecticut, they still could not prove anything. We are continuing, maybe illegally, but we are continuing our program of education and referral. Now, many, many women call in for information as to where they can get help. And for the past 4 years, we have been referring women to the 3 out-of-state centers, which just border the boundary of Connecticut. And we have been subsidizing these centers financially for quite some time to help, particularly on these indigent cases. I would say that we have had approximately 20,000 women go out in the last 4 years.
So some interesting aspects of that. First of all, both of them making the economic argument. Mm-hmm. What's your reaction to that?
A couple of things. Over the years, especially poor and minority women have sometimes asked the question. So when Dr. Buxton said, these are the people that really need it, in the literature, even today in the contraception magazines, there's a question as to whether some poor and minority women feel that people who are better off from more elite institutions really want them to have it. You have the controversy over President Nixon's National Security Memorandum, where he says we have to contracept the third world or they're going to be threatening us with their numbers. You have the debate in the 1990s when they were giving Norplant a kind of longer-acting contraception to poor women in cities in exchange for money or gift cards. So that economic argument, it both makes a lot of sense to people. They say, oh my goodness, you know, people can't afford X number of children. but it also has engendered a bit of a backlash.
Yeah, I think that there is a complicated story. I mean, reproductive justice advocates have made it a centerpiece of their advocacy to talk about how certain family planning projects really targeted women of color. And that, at the time that Griswold is being decided, states are not just repealing their family planning, their contraceptives law. States are passing laws, creating programs to provide family planning. So there is at this moment, too, a population movement, a population control dynamic happening. That said, I think it's really fascinating that one of the understudied parts of Griswold is that the clinic saw itself as providing economic justice for its clients. It was a public clinic serving low-income women who couldn't afford private doctors, who couldn't get in a car and drive to Rhode Island. And that the message about curtailing poverty and poverty's effects on reproductive choice is an important one that I think, even with its darker side, is something to think more about.
I'm going to pause for a few minutes in our narrative and take some calls. First is from Peter in Elizabethtown, Pennsylvania. You're on the air.
Thank you, Ms. Swain, and wonderful guests. I can't believe my good fortune getting to speak to you again. This case really fascinates me, and for a long time when I heard it referred to, I thought it was a case about reproductive choice, reproductive freedom, family planning, etc. But everyone, I've since learned it centers on privacy. This really confounds me because here we are, over 50 years later, and I'm like, where's my right to privacy? Why hasn't this been extended? As you said, I live in Pennsylvania. I'm pretty sure that if I grew certain plants in my home, especially cannabis, for my own use, I could get in trouble. I'm pretty sure if I set up a wonderful device for distilling the essence off of fermented grain to make my own whiskey, I'm pretty sure I could get in big trouble for that. I'm not a smoker, but as far as I know, I might even get in trouble for producing tobacco for my own use without, paying taxes and getting permits. So please, why has Griswold v. Connecticut not been used to expand everyone's privacy rights and maybe put an end to our insane war on drugs?
Thanks, Peter.
That's all I'll say.
Okay, thanks for your call.
I think one answer is that the right to privacy articulated in Griswold, which I think we'll talk about, the court confined that right to privacy to personal relationships in many ways, to a sphere of marriage, parenting, sexual expression, and here I'm talking about a trajectory from 1965 to 2018, but cabined off the same types of inquiry for economic affairs, for markets. And a lot of what you're describing, the court has said, implicates business affairs, states' regulation of markets. You may not be satisfied with this answer, but the court has made that distinction. So, privacy has its limits, which I think we'll discuss.
Josh is up next in Algona, Iowa. Hi, Josh.
Hi. How consequential of a justice was William O. Douglas, not just in this case, but in the overall history of the court?
Thank you.
Well, I have to say, I think his being consequential has a lot to do with this case, because he articulated a right of privacy, again, that was not in the text of the Constitution, and indicated very much an opinion on behalf of living constitutionalism. When I went back and reread his dissent in Poe versus Ullman, the case before Griswold, reread his opinion in Griswold, I was struck by how many of the phrases about a living constitution are still in contest today. So I think a lot of his importance deals with it. I would defer to others as to later cases that he was a part of, because I don't know them quite as well.
Have any comments on Justice Douglas?
Justice Douglas's opinion in Griswold, and just to take that, I think he was significant on the court, but the Griswold opinion, for reasons we'll discuss, has been criticized for its use of the word penumbra, ridiculed even. And I think history has been much kinder to Justice Douglas and his opinion in Griswold as saying something important about core privacy rights at the heart of the amendments in the Bill of Rights. I just add that.
Next up is Julia, watching us in Palo Alto. Hi, Julia.
Hi. You've talked a little bit about Griswold's foundational role in recognizing a right to privacy that's since been extended to include the right of unmarried people to access contraception and the right to abortion and so on. Some, including famously Justice Ginsburg, have opined that the right to an abortion might be more appropriately and securely located in an equality right rather than a privacy right. And the same could be said of contraception in Griswold, since the ability to decide when and if to become pregnant disproportionately affects women. Can you hypothesize a bit as to the legal implications on this line of cases and on the attendant policy issues if Griswold were to be decided on an equality rather than a privacy basis?
Thanks, Helen. Alvarez, we'll start with you.
Yeah, I know Justice Ginsburg has said that, and I think had it been done on equal protection, and then had, for instance, the Lawrence case, which we'll talk about later, which was about sexual orientation and sex, followed it in equal protection, had the same-sex marriage case been done on equal protection, I think, you know, she is not alone in thinking that it might have had a firmer foundation. And part of that is because the fight over how you look at a constitution and find a non-textual right somewhere in the 14th Amendment, that fight is so hot. But the question about equal protection is slightly less hot. So I actually think that possibly Ginsburg is right that Roe would have had a firmer foundation. I also think that Lawrence and the later case on same-sex marriage, Obergefell, might have been seen to have a firmer foundation. The state would have had to articulate its interests against the unequal allocation of rights in those cases, and it would have been harder for, I think, the state to do so.
We're going to go back to our narrative. Rachel Rebusche, you said earlier that the earlier case, Poe, needed an arrest. That's why it didn't go to the court. So we're going to learn that part of the story. We're going to listen to Dr. Buxton and Estelle Griswold's subject, that Rosemary Stevens is her name, and she was part of this case, and she's going to explain how she came to be part of it.
I was the witness against the doctor, Dr. Lee Buxton. I got involved through the Yale Law School. It seemed at the time that it was very difficult to find a witness. You needed a married woman who was plausible, whose husband did not object, and could stand up in court and give evidence. I was examined by Dr. Buxton. I was given further advice. Robert and I had gone directly from the clinic to the police station. They wanted to know just about what had happened. In other words, yes, I did go to this birth control clinic. Yes, I did see Dr. Buxton. Yes, he did give me advice. Yes, I did see Mrs. Griswold. It was very straightforward. We'd accepted advice, but we hadn't actually used it. So the policeman with sort of an avuncular charm sent us away to come back tomorrow and say that this had also been used.
So it's proceeding step by step by step. There's another aspect to this, even though that the folks in Connecticut were planning for this, didn't count upon. And we're going to meet next from, again, this 1962 CBS News report about a neighbor whose name is James Morris, who got involved in this case, and we'll learn about his role in setting the wheels in motion.
Well, I'm 100% against birth control because it's immoral. It's the same as prostitution or abortion or in any other in those immoral things. When rock and roll came to New Haven, the mayor of New Haven threw him out of town, and probably every city in this side of the Mississippi threw the man out of town because he was against it. He realized it was against hurting the children. Well, when birth control come to the town, what did the mayor do? He says, when I called him, he says, that's not my department. Call the police department. The police department says, call the I'll call the prosecutor, and the prosecutor says we're not accepting your complaint. That's up to the police department. Finally, after I had to go to the press and to the radio and everybody else, I finally was allowed to file a complaint with the chief of police in New Haven. Just an ordinary citizen with 5 children who was never elected to office. I had to go to the chief of police and beg to file a complaint.
So what do you both think of Mr. Morris and his role in all of this?
I always like to make sure that, we don't judge people from the past by our same standards. And he was not alone in this. I mean, the attorney for Connecticut was making similar arguments that straight out about morality. I think I want to say it's the Anglican or Episcopal Church at the Lambeth Conference in 1930, only 30 years before, had declared contraception okay and only for married couples. This was a very different time, and things were changing drastically. As Rachel points out, the invention of the pill, and all else that was going on in the 1960s, and a lot of people were very frightened about all the changes. But he was not alone.
Mm-hmm. So Connecticut found itself in court over this case. What happened?
Well, they lost.
Planned Parenthood.
Planned Parenthood lost before in the state court. Before the Supreme Court of Errors in Connecticut. And the Connecticut Supreme Court refused to reconsider arguments that they had decided in Tileston and in Poe, saying that the law was not unreasonable, it was not arbitrary, it was a proper exercise of the state's police powers. And so Planned Parenthood appeals to the U.S. Supreme Court, which is ready to hear the case.
Katie Rohraback, whom we saw earlier, was an important part of this part of the process. Can you talk about what her role was?
Well, she was the main attorney in the courts in Connecticut. She filed very forceful arguments at that point, introducing the idea that this was a violation of people's right of liberty and privacy. Previously, in the Tileston and Poe case, the arguments were more about this is a threat to people's life if you don't let them use contraception. But she is now introducing this idea that people have rights that may not be explicitly articulated in the Constitution, but they're very important for personal freedom.
And can I just, Emory Law, Martha Feynman is a professor at Emory Law School, bequeathed her files and papers, Rohraback's files and papers, and there's a terrific archive of her professional work at Emory Law. And I have to put in that plug because it's really a wonderful resource.
So the New York Times, January 18th, 1963, had the headline, "To Lose Appeal on Birth Control." But proponents of the repeal of the law decided to try again legislatively. And it went to the Connecticut legislature. The House passed a bill repealing the law in 1963. But what happened in the Senate?
It loses in the Senate. And if you actually look at the short histories of it, it says it was a very Catholic Senate and they didn't believe in it. That's a very interesting conversation by itself. One of the things I noticed is when you look at Poe versus Ullman, that earlier case, one of Justice Douglas's statements in there, he says, don't worry about the Catholics on this. He says, there's plenty of Catholics that understand that this is a private moral thing and they don't really think that you need to have a law that goes into people's bedrooms. The fact is there was a dispute among Catholics and it ended up showing up in the Connecticut Senate, which refuses to pass the law. Some thought, whatever we think about it morally, you don't have to make it illegal. And others thought, no, the law should reflect a moral opinion on this.
So F.J. Darnell on Twitter asked not so much about individual Catholics, but how did the Catholic Church respond? Were they involved in this in a very forward way?
There was a debate. If you go look at Catholic literature of the time, you see that John Courtney Murray, some people may have heard of him. He's a very famous Catholic theologian. He's a priest. He's responsible basically for the Church's Vatican II document that says religious freedom for everyone is a good thing. He writes, and Douglas quotes him. So interesting. He quotes this Catholic guy in his dissent in Poe and says, Courtney Murray understands the difference between something that is privately a moral matter but shouldn't be enforced by the law. This is not a law that anyone should support. Other Catholics thought that the law should try and uphold a certain standard of morality. People are more likely to be promiscuous if they separate the idea of babies from sex. and we should hold the line in Connecticut.
I'm going to take a few more calls. Next up is John, Fort Wayne, Indiana. Hi, John.
Hi. Yeah, my name is John Martin, and full disclosure, I am a retired attorney, and I remember we discussed and learned about this case in constitutional law way back in 1976. And what I always remember about this case was the penumbras and emanations. And as you know, it's a pretty short opinion, but they came up with this right of privacy nowhere in the Constitution through penumbras and emanations. I don't think anybody can disagree. It was a dumb law. It never should have been passed. I mean, particularly we look back today, I can't imagine any state would have such a law. But for 9 unelected judges to decide through penumbras and emanations that there's this right of privacy, which means we got to declare this law unconstitutional. The real argument should have just been to the legislature. They're the ones that they should argue, get rid of this law. And it still baffles me that the 9 unelected judges can use penumbras and emanations to find some right of privacy that's nowhere in the Constitution.
Thanks. We'll let that stand as a comment and go on to Jeremy, Washington, D.C. Hi, Jeremy.
Hi, good evening. Huge fan of the program and so glad that C-SPAN and the National Constitution Center brought it back for a second season. My question relates to the piece that you had from CBS in where Dr. Buxton talked a little about the economic inequality effect that the law had, and you and your guests had talked about how, you know, women who had means to see a private doctor wouldn't be affected by this law, but it seems to me that the law would equally apply to private as well as a public clinic is there. And so I was just wondering what the basis of Dr. Buxton's statement there was.
I think Dr. Buxton was referring to the also illegal practice of private physicians writing prescriptions for women or providing women with contraceptives under the table. That if you knew where to go and who to ask, as with any type of service that is either on in an illicit market or is something that you would pay for that's not provided by law but is accessible through other means, you could find someone to help you if you had enough money and information.
Gary is in Marlton, New Jersey. Hi, Gary.
Hi, thank you for taking my call. I have a question, but first a comment. As far as the Catholic response, in 1968, Pope Paul VI declared opposition to birth control in his paper Humanae Vitae. So that's just a comment to follow up on an earlier question. But my question is, I came across this ruling when researching the history of the discovery of the birth control pill. And the ruling was in Griswold, it surprised me that it only applied to married couples. And then the Supreme Court then had to make a separate additional ruling 7 years later that made it apply to all women, married and unmarried. And it struck me as odd. And my question is, was the Supreme Court much different 7 years later? Was the makeup different? Why didn't they make the original ruling broad to cover all women, not just married women in the first case? So that's my question.
Well, interestingly, the Connecticut law applies to unmarried women and men as well. And Planned Parenthood decided to press the marital issue because they thought it was a stronger argument, a stronger anchor for a privacy right or a right to health or life and liberty. And at oral argument, the justices pressed Emerson, who argued for Planned Parenthood, isn't this an equal protection problem? You're only talking about married people. Shouldn't you also be talking about unmarried people? And the court decided not to take up the equal protection issue. They decided to take up the privacy issue for married persons. And I think there's some thinking that it was a way to cabin the privacy right at that point in time. But the oral argument, I think, hints that it was always likely to give way on equal protection grounds across the marriage-unmarried line.
If I could add to that, I think you pick your plaintiffs, right? And at the time, the public was not going to be very enthusiastic about rights of contraception for single persons. The idea that responsible married people wanted to determine the number and spacing of their children was going to get a lot of support. If they had gone in from the first with rights of single person, here's the problem. It was very easy for the right of married people to trump the state's interest in what, right? The state said something about morality or preventing these couples from having adultery. The state's interest didn't seem quite as strong. On the other hand, if the state is prohibiting distribution of them to single persons, then they might have made a case before the court. And indeed, the concurrences indicate the court said, listen, laws against premarital sex, they're fine. And if Connecticut, and they said that in Griswold, so if Connecticut had gone forward with the rights of single persons, Connecticut might have said, we do have an interest in dampening the willingness of single persons to have sex outside of marriage.
Jack is in Davenport, Iowa. Hi, Jack.
Well, family planning decisions appear to belong exclusively to women. Privacy apparently belongs mainly to women because of this Griswold case. Doesn't that take husbands out of family planning decisions? And doesn't that mean that men are removed from a vital part of the marriage life?
There's so much there. Let me try to be brief. Because birth control has been made for women and not men, rights to use it is, have been a right that has been handed to women. When they try, and you can read from time to time, Mother Jones had an article a few years ago. There was one in the New York Times not too long ago. When they try to do birth control for men, sometimes men say they don't like the side effects, and so they stop the trials or they don't proceed with it. When women don't like the side effects, they keep going with the trials. They often put it out in the public market anyway. With regard to men, the question of men's rights didn't really come up in contraception because so much of this was about the pill when it was invented. Men's rights vis-a-vis family, they come up when parents are thinking about choosing schools for their kids or custody, or in the Lawrence case, which we'll discuss shortly, about two men and rights to have a sexual relationship. But in terms of family planning, contraception and abortion, because of how it's been set up by the pharmaceutical companies and thereafter because women are the ones who bear children, it ends up being put as a woman's right.
And could I add that condoms, which, because of exactly what Helen said, there hasn't been a male pill established. Condoms are an effective way for men to control contraception. We're always available in Connecticut, and we're always available to men. And I think it also bears mentioning that many of the laws that police morals were attempts to police women's sexuality and women's role, women's sexuality in family formation, legitimacy, and other related issues. So extension of privacy rights to women and striking down laws that policed that sexuality, one consequence as well.
Griswold versus Connecticut made its way to the Supreme Court and was heard in oral argument on March 29th, 1965. Here's a look at the court in that time. The Eisenhower appointees included the Chief Justice Earl Warren, John Marshall Harlan II, William Brennan, Potter Stewart. There were still Roosevelt appointees on the court, too. Hugo Black, and we'll talk about his dissent later on, and William O. Douglas, who authored the majority opinion. A Truman appointee, Tom Clark, and Kennedy appointees, Byron Whizzer White and Arthur Goldberg. So we're going to listen to Thomas Emerson's predecessor. You mentioned earlier that a Yale law professor by the name of Fowler Harper had initially headed up the legal team to present Connecticut's case to the Supreme Court, but he took sick and ultimately passed away. And that's when Thomas Emerson came into the case. But we have Fowler Harper for you to listen to, talking about the arguments in this case.
The current cases, the case of Dr. Buxton and Mrs. Griswold, the two who have just been convicted for, as accessories for prescribing and advocating contraceptive device, not only involve the Due Process Clause and their right to advise people with respect to matters of their privacy, and about Dr. Buxton's property interest in his profession, because he claims that this law prevents him from practicing his profession according to scientific principles and according to his own conscience. And thus it takes his property without due process of law. There's also involved in this case the problem of freedom of speech under the First Amendment, which prohibits, the First and the 14th, which prohibits Congress and the states from passing any law abridging freedom of speech. Certainly one of the most intimate and sacred relations of life is the relation of a man and his wife in the privacy of their own home. And when the long arm of the law reaches into the bedroom and prohibits a man and his wife doing what they want to do and what medical advice suggests that they do, it seems to me that this is a merciless invasion of the freedom and liberty of the citizens of this country.
So that's an outline of the thinking of the Connecticut defendants in the case. There is something called a rational basis test that the court can apply to laws. And since Connecticut and Massachusetts were the only two states that had this, couldn't they have simply dealt with the case this way? Why did they go so far as to develop this legal framework?
Right. So earlier, Rachel spoke of a state's police power. A state has the right to make laws that govern health, safety, welfare, and they used to also say morals, right? Health, safety, welfare, morals. And if a state makes these laws, ordinarily, a court takes a look at them and says, is this law rational? Is it related to a state interest that's within health, safety, welfare? You know what? It's fine. It's when a law touches a constitutional right that a court says, now we're going to take a harder look at it. A little harder look today if it involves, say, a distinction between men and women, a really hard look if it has a race distinction, and a really hard look if it touches upon a fundamental right. And those fundamental rights, some of them are in the text of, the Bill of Rights. Griswold says some of them aren't, but they're still fundamental rights, and 5 out of 9 members of the court can tell you what they are. So this is what the Planned Parenthood of Connecticut wanted is, let's have the court say it's a fundamental right, and then they'll take a hard look at the states limiting it.
It was interesting listening to Fowler Harper, though, talking about the 14th Amendment, Due Process Clause, freedom of speech, First Amendment. So how did it coalesce into the direction that it actually went?
Well, I think that Planned Parenthood argued that all of those amendments had aspects of privacy that were fundamental to people's life and liberty. And so in their briefs then before the court, they said things like there are various amendments to the Bill of Rights, the first, the third, the fourth, the fifth, the ninth, the 14th, all of which appear in Douglas's opinion as having penumbras that protected the privacy of the home and the privacy of the marital relationship, and that was a distinct set of fundamental, those amendments said something about marriage and the home that was different than other regulations that could pass the laugh out loud test. A rational basis review in which if the state has any reason for passing the law, it'll stand. But in this realm of private decision making, in these personal relationships, the state has to have a better reason.
Joan is watching us in Fort Myers, Florida. Joan, you're on.
Okay. It occurred to me when I was watching this, and I was questioning why, when it comes to both contraception as well as abortion, did no one say this seems to be, to me, a violation of the 14th Amendment, a form of slavery by taking away the right of a woman to control her own body? It's a particular interest to me because I gave birth for the first time in 1966, so this period is very meaningful to me.
Anyone follow that legal argument in presenting this case?
Well, I have heard that argument made. I've heard it made legally. I've also heard it made in sort of ethics or philosophy terminology. You know, I've heard some people refer to the United States as original sin as slavery, right? Slavery and the law regarding that, and the law after regarding Jim Crow, and the law today on racism, non-discrimination, have really got their own niche. And we don't tend to cross over between sexual expression interests or whether it's contraception and abortion and slavery. It tends to be, there's a legal expression lawyers use, sui generis, a thing in itself that does not get used in other categories.
So we know that Thomas Emerson was part of the legal team. What happened to Katie Rohrbach? Was she part of the team when it made it to the Supreme Court?
She was part of the team, but she didn't argue the case. She was on the briefs, and I think there's conflicting evidence about what happened in her role, but from what I've read, she remained part of the legal team, working on the strategy, writing the brief, and supporting Emerson, who delivered the oral argument.
And certainly, you know, the arguments from Connecticut that she was making from the Connecticut courts followed through to the Supreme Court brief. So that, to the extent we have evidence of her role, there seem to be similar arguments.
Before we go on to Connecticut's side, a word or two, please, about the Warren Court at this point, 1965. Where was it in its long history of expansion of rights by this stage?
Toward the beginning, to the great surprise of the Republican who had appointed Warren. You've also got Harlan, who was appointed by Eisenhower, to the great surprise of, you know, to many people, his opinion that there are non-textual rights in the Constitution. It was not, I don't know, I wouldn't call it the heyday of what people commonly call the Warren Court, with an agenda that seemed to have a lot of Republicans making a lot of decisions that now would be called liberal. This was toward the beginning of that period.
What are your observations about the Warren Court that people should know?
You know, I think that commentators of the era were surprised by Griswold because the Warren Court, so many of its landmark cases had involved criminal justice, rights of free speech, poverty, entitlements by the state, but hadn't been issues related to marital privacy or sexual expression or the like. And so I think Griswold, in some ways, is of a kind in the debate that Helen described between deferring to legislatures or taking a harder look at legislation as judges when it touches on fundamental rights. That was there. But this, I think Griswold is also stands apart from other notable Warren cases that preceded it.
Another tweet about the Catholic Church in this debate. Athos Krantz says, in the Pope Paul VI decision on birth control, there are noted exceptions that were allowed for the use of contraceptions, whereas Connecticut seemed to outlaw even the exceptions.
Right, and even into today, Humani Vitae, in fact, there's a 50th anniversary of Humani Vitae because it went out in 1968. That is happening right now with all kinds of conferences on it. The exception was when it was being used for the mother's health, that it was used to treat something, a health condition, but it was not being used for contraceptive purposes. Connecticut didn't say that, and there was all this confusion, and it comes up among the justices both at the state and the federal court. Gee, it seems nobody is getting in the way of use of contraception for disease, but there's no law that says that's okay. Yeah. So it was really, as Rachel indicated earlier, it was people doing what they could get away with until they eventually decided to push this law in the face of the authorities and get it decided.
And just an interesting aspect of that as well, just from the legal side. So Connecticut, in Poe and Tilliston, the Supreme Court of Connecticut had ruled that there is absolutely no exception for life or health, but the abortion law in Connecticut at the time did allow abortion for the life of the pregnant woman. So the abortion law was more liberal or less restrictive than the birth control law in 1965.
We're now going to hear Connecticut's argument before the court. We're in the era now where there are audio recordings of all of the oral arguments, and after they're made, they go to the National Archives, where we're able to find this for you. Joseph B. Clark was the attorney arguing for the state of Connecticut. Do any of you know any biographical information about Mr. Clark?
I don't think I do.
I think he was in the Attorney General's office for the state, but
he was.
And this was his only case before the court. So let's listen to how he fares in an exchange with Justice Potter Stewart.
Mr. Clark, what you're touching on now leads me to ask, what is the purpose of this legislation in Connecticut? Your basic argument in your brief, and so far in your oral argument, is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is to
To increase the population of Connecticut, or to impair its decrease, or is it what?
Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is a. We could make this claim valid.
So what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this purpose, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction, that there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Okay, my two law professors, what are you hearing in that attorney's argument on behalf of his state law?
I hear that no one, no justice, and not even lawyers for Connecticut believe the state purpose that Connecticut had put forward, that the law banning contraceptives for married, unmarried, but for married particular, was any good at deterring people from extramarital sex. It seems that no one is buying that argument, and that's what you really hear in the conversation. You say that's what this state law is meant to do. Is it doing it? I mean, Clark argues later in his argument, well, this is just a question of pure power. Does Connecticut have the power to enact moral legislation? And so even if you don't believe that we are accomplishing the goals that we set out to as a state, is it that we have the power to pass this law?
What strikes me is that by the time he got to the Supreme Court, he wasn't able to articulate this. But I mean, this is a question for me that goes to any lawyer coming before the Supreme Court should have this very ready to hand. He could have made the argument that, you know, we do know, actually there's this sort of law and economics literature on contraception and sexual expression. And we do know that people think that when a risk is insured against, they'll do more of the risk. And he could have said, yeah, I know it only applies to women, really, well, because they're only making birth control for women. So no, it's not about trying to reduce extramarital affairs by both parties, but maybe it'll help reduce them among women and maybe vis-a-vis the men that they might be sleeping with who are not their husbands. I mean, it's not something that people would love to hear today, but at least it would have had a little bit more rationality about it. I'm really struck by his inarticulateness at the point of the Supreme Court.
So Joe Paulson on Twitter says, Joseph B. Lost Claus Clark is akin to the poor guy who tried to argue against Gideon last week in landmark cases. And he goes on to remind us, and it's important, Justice Stewart dissented in this case. Yes. And still the guy looks lame here. So maybe you can talk about Justice Stewart's, what conclusion he ended up coming to in this case, even though he was really questioning the fundamentals of the law.
Mm-hmm. He was, and yet Justice Stewart apparently had a strong preference for federalism, for the power of states to enact laws that are within health, safety, welfare. The more likely answer is that he believed in what Rachel talked about as the later argument of Attorney Clark, who says, I think this will prevent immorality. He couldn't articulate how, but Justice Stewart thought that it was very dangerous to start down the road of 5 justices sitting as what he called a super legislature, making laws for Connecticut when it really should be making them for itself.
And Justice Stewart is famous in this case for calling the law uncommonly silly.
Yes.
So it's apparent in that line of questioning. But he wrote and was concerned about hearkening back to days of Lochner, which is a famous
yes, so important.
Season 1 of Landmark Cases.
Season 1,
yes. Case, yes. And the connection between Lochner is?
So Lochner is a case, New York had regulated the hours that New York bakers could work, as those of you faithful Landmark Cases viewers would know. And the Supreme Court struck it down as an infringement on liberty, the right to contract. And it's really after Lochner that the court refuses, as we've been discussing, to use its power under the 14th to strike down or any aspect of the Constitution, these economic regulations based on due process arguments about the wisdom of state regulation. And the post-Lochner era, Stewart is writing in Griswold about the court's concern that it stay in a post-Lochner moment.
Yes. If I could add to that, it was really interesting how when Planned Parenthood was arguing this case in the brief, it said, we are not going back to a time where the Supreme Court can strike down state laws regulating minimum wage or minimum amount. Don't worry, we all know that's bad. But we think we've threaded the needle by saying states can improve the quality of life for people, limit their hours, up their wages, pass laws on it, but they can't restrain fundamental rights. So you see the brief trying to thread that needle around Lochner. Lochner was a very dirty word in those days. So when Stewart says we're going back to Lochner, that's very resounding.
We have half an hour left to go in this edition of Landmark Cases. We're talking about Griswold versus Connecticut, 1965, Planned Parenthood case by which the 7-2 decision established the right to privacy. In our last half hour, we're going to talk about the decision and then also about the framework that it established that has led to several decades of expanding privacy cases and rights for Americans as a result of it. Lots more time for your phone calls. Put the phone numbers on the screen, and also you can send us a tweet as well. So the case, actually I'm going to take a call and then we'll go back to the decision. Mark is in Sanford, Maine. Hi, Mark. You've been waiting. You're on the air.
Yes, hello. I just had a question. The penumbra, I don't think many of us that aren't familiar with the law know too much about the penumbra. We vaguely know what the Constitution means. So I'm just curious if you could explain a little bit more about the right to privacy and all the rights that come under the Bill of Rights with the penumbra. And then also I wanted to mention Griswold v. Connecticut. That case really, if you look at it, even though we're not, a lot of us aren't legal scholars, it seems that the court did the right thing. That they looked at a person's right, the right to privacy, and they made a good judgment. In my view, I believe, and I believe many others that my friends and colleagues believe they made the right decision too. But my question is, why? I know we got different people with different preferences and stuff, and this religious freedom now that's the rights that's kicking up, which I don't like that, because I think we all should have an individual religious freedom right, not push our rights on others. And I wondered if you could touch base on our rights, that people shouldn't be able to push, even though it's our rights, we shouldn't be able to push it on to others. Can you touch base on that and explain that to us?
Okay, let me get into the decision, and then he really tees up with those questions, a lot of important topics for us. So June 7th, 1965 was the day the decision was handed down. As a side note, our producer reminds us that's also the same day the Gemini 4 astronauts returned to Earth after the first U.S. spacewalk, big times in the 1960s. As we mentioned, it was a 7-2 vote for the majority, and there is the breakdown of the majority and the two dissenters, Justice Stewart and Justice Black. But here is an excerpt from William O. Douglas's majority opinion. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or for worse, hopefully enduring and intimate to the degree of being sacred. So take us down his legal reasoning here.
So this will answer the penumbra's question as well. What he says is, so there isn't in the Constitution a text that provides a constitutional or fundamental right to contraception. There is, however, this language in the 14th Amendment that also applies to the states that protects, I'm getting ahead of myself. No, he doesn't put it in the 14th Amendment. He says there is a right of privacy that it is part of, even if it's not explicit, in other amendments of the Constitution. In the first, he says, it says free speech, but we say there's freedom of association, which is kind of a privacy thing. In the right not to have your home searched, in the your right that not to quarter soldiers except under particular circumstances. He says, all of this speaks of a right of privacy. And he even mentions, but doesn't rely heavily on, the Ninth Amendment, which he says reserves things to the states that are not taken by the federal government. And he says, the right of privacy is not in any of them. But if you look at these other things, these other elements of the Bill of Rights that I've mentioned, there are penumbras and emanations. There are things without which the explicit rights are not really strong enough. And I'm going to say that the right of privacy is in that fuzzy penumbra emanation thing coming out of some of the first of the 8 amendments to the Bill of Rights.
Would you be kind enough to define the word penumbra for people watching tonight?
Well, the shadow of, it's Douglas was ridiculed, Justice Douglas was ridiculed for using the term penumbra, are you a Latin scholar, and the idea that there's a shadow cast by the amendments that concludes a privacy stake, a privacy interest that makes the first, third, fourth, fifth, ninth, 14th Amendment do not make sense without some privacy background. And so privacy in the shadows, lurching forward into the daylight.
So Akhil Amar, who is a Yale law professor who was our guest last week, has a book on the Constitution. He described William O. Douglas's arguments as strained in this. And he went on to say that John Marshall Harlan II, who is a noted constitutional conservative, made a more, he saw a rational argument, saying essentially that America's basic practices rendered Connecticut's oddball law unconstitutional.
So there's a couple things going on here. One is, when we talked about Lochner, it seemed that Douglas did not want to find a right in the 14th Amendment for a liberty that people had that could cast down, that could strike down state laws. Why? Because that's what Lochner did. And it said people had these economic rights. So one, he was probably trying to avoid putting it in the 14th Amendment like Harlan did, because he wanted to avoid Lochner. And number two, he might have been afraid of just going too far. And he wanted to start with things that were definitely in the Constitution and say there's a firm tie. Whereas Harlan makes this argument, relies on well-loved cases. Meyer versus Nebraska, Pierce versus Society of Sisters, that say, of course parents have a right to decide their children can be taught German. Of course parents can decide their children can go to a religious school. And Harlan says, look, in the past, this court has found that people have rights that are not in the text of the Constitution. We did it through the 14th Amendment. Those cases are popular. I don't see why we can't put a right of contraception right alongside them.
I'm going to get behind time, so let me go on to Justice Black's. We had already talked about Potter Stewart's dissent. Here's a bit of the language of Justice Black. And remember, as you're reading this, that Justice Black is sometimes called the originalist before Antonin Scalia got to the court. He wrote, "There is no single one of the graphic and eloquent strictures and criticisms fired at the policy of this Connecticut law, either by the court's opinion or by those of my concurring brethren, to which I cannot subscribe, except their conclusion that the evil qualities they see in the law make it unconstitutional." So what's he saying?
So I think Justice Black is focused on just this debate we're having about the textual nature of rights, the originalist position as you described. And he says, there's no fundamental right to privacy because the Constitution only speaks of constitutional provisions designed to protect privacy at certain times with respect to certain activities. So if Justice Douglas, if his argument is strained, it's because how can you show that a law on married persons' access and use of contraceptives helps protect, uphold, secure the Third Amendment or the Fifth Amendment of a right against self-incrimination? There's a gap there. And he said there's a gap that we're trying to fill that doesn't make sense in light of a textual approach to the Constitution. So, he's also famous for saying he liked his privacy as much as the next person, as much as the next one, but that without adhering to the text of the Constitution, the court becomes a day-to-day constitutional convention, a super agency that sits in judgment over the legislature.
As we've heard, the Griswold decision relied on several constitutional amendments. So let's listen next to current Justice Elena Kagan and unsuccessful Reagan Supreme Court nominee Robert Bork talk about their views of the Griswold case.
What I objected to was the way in which this right of privacy was created, and that was simply this. Justice Douglas observed, quite correctly, that a number of provisions of the Bill of Rights protect aspects of privacy, and indeed they do, and indeed they should. But he went on from there to say that since a number of the provisions did that, and since they had emanations, by which I think he meant buffer zones to protect the basic right, he would find a penumbra which created a new right of privacy that existed where no provision of the Constitution applied.
I actually think that Griswold and the holding in Griswold does have grounding in the constitutional text. And the way most justices have thought about this is that the 14th Amendment, the Due Process Clause of the 14th Amendment guarantees liberty, and that it guarantees, when it guarantees such liberty, it means more than freedom from physical constraints. And it also guarantees more than procedural protections, that there's some substantive protection of liberty that's incorporated within the 14th Amendment of the Constitution.
And so we'll move from those arguments, which we've been talking about, to a reaction around the country. First, the New York Times front page, June 8, 1965, High Court bars curbs on birth control, finds Connecticut law invades privacy. And to the Washington Post, same day, birth curb in wedlock held legal. High Court 7-2 voids law barring contraceptive use. So now let's spend some time on Griswold's legacy. First of all, the people. What should we know about Estelle Griswold or Dr. Buxton or Attorney Emerson? What happened to their lives after this case?
I do know that in the case of Estelle Griswold, she ended up in a dispute with Planned Parenthood, and it was largely over where the clinic should be and could she live in the gatehouse and take care of her husband there. And she did leave because of internal disputes, but was certainly a vocal supporter of women's right to contraception through to the end of her life. I think she died maybe in 1981. She lived a long 81 years.
And eventually the state of Connecticut put her in their Hall of Fame for accomplishments of people in the state. Buxton took a leave of absence from Yale in 1965, just as the case was being heard. He lived until 1969. And Mr. Emerson continued teaching at Yale Law School, died in 1991, and never argued another case before the Supreme Court. So we've mentioned this a few times, that this started a number of cases where this was checked. The next one was Eisenstadt versus Baird, which was 1972. Here's an excerpt from that majority opinion. It is true that in Griswold, the right of privacy in question inhered in the marital relationship. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion. So, as you've both described this before, Connecticut didn't want to go too far. So they put their foot in the pond, as it were, with the hope that the court would continue. So what got this next case to the court? What was happening in society or in the court that they moved on to this broader expansion to all people having the right to use contraceptives?
I would say, everything that adds up to the words the sexual revolution, the idea that single persons had and were likely to have, non-marital sexual relationship, and the argument that wouldn't it be better if they used contraception and didn't get pregnant. Bill Baird himself, it's interesting, he would go to Catholic University's campus here in Washington, D.C., and he would hand it out there, and he would hand it out at other Catholic campuses to try and provoke a controversy. So there were public spectacles on the topic, and there was, again, the emergence of the sexual revolution among younger Americans.
Here's a longer tale of Griswold in cases, in addition to Eisenstadt, that have been heard and decided by the Supreme Court. In 1973, it was the framework for Roe versus Wade, an issue we're still debating in society today. Carey versus Population Services International, 1977, which found that birth control was legal for those as young as the age of 16. Lawrence versus Texas in 2003. Which was the sodomy ruling, and Obergefell versus Hodges in 2015, the gay marriage case. So walk me through what's happening in the court and society and how they continued to use this case, Griswold, to expand rights.
Well, Griswold becomes important culturally and legally. So culturally, as Helen mentioned, sexual mores are changing. Women's roles inside and outside marriage changing, technology around reproduction changing. There is an evolution since Griswold in reproduction and in decisions around sexuality that are reshaping the U.S. Story for family and for gender. As a matter of law, Griswold is interpreted in this line of cases as providing an anchor for substantive due process, that there are rights that are fundamental to people that are not explicitly enumerated in the Constitution, but nonetheless states may not violate. You see that in Roe, upheld in Roe v. Wade, establishing a right to abortion as in the 14th Amendment, constitutional right to privacy, and then upheld, though the trimester system is repealed, in Planned Parenthood versus Casey, again, a substantive due process case, 14th Amendment, a right to privacy. Those link back to Griswold and the debate that the concurrences in the majority were having with the dissents.
Just a couple of quick points on that. One, when the court later talks about Griswold, today you wouldn't know it wasn't a 14th Amendment substantive due process case. They often treat it as that. Number two, we went from a right of privacy inside a marriage, inside a marital bedroom, to a right to make important decisions in your head. And these include rights regarding sexual expression. And third and finally, sexual expression becomes more and more and more separated from community, from the fact that it's where children are created, or from the fact that it might be, that it does or does not take place in marriage. It gets separated from that, and it becomes a right to express yourself, a right of identity. And so you see this substantive due process right of sexual expression morphing in Lawrence, which is the sodomy case, in the Casey abortion decision, and finally in Obergefell, to a right to establish your identity. So it went a long distance from where it started inside the marital bedroom in Griswold.
But I would add, Justice Kennedy's language in Obergefell could easily have been lifted from Griswold. Sacred, enduring, lifelong. I mean, as much as there is an individual component to the decisions people make to marry, to express themselves sexually, to have an abortion or to seek out birth control, Obergefell also is about community, a community of people who are seeking to raise children, a community of people who are seeking to express love and do it within the confines or the institution of marriage.
The court itself has undergone enormous changes during those decades. Can you both talk about what happened in the court and how it's changed?
Well, when we were looking at Bork, Rachel reminded me that Kennedy was the justice who ended up being appointed at that time. Kennedy is the swing vote. The court seems to be 4-4 on either side of these. Is sexual expression protected in the Constitution in the way that Griswold, Casey, Lawrence, Obergefell would say so? And the court could definitely shift within the next couple of years. The right of contraception, the constitutional right of abortion were affirmed and not overturned. I think no matter what happens to the court in the near or distant future, I don't see Griswold going down. I see it being just spoken of as if it was a 14th Amendment substantive due process case. But it's quite possible that Roe and maybe Obergefell might be part of a shift in the court that might end up changing those.
Any comments on the court change?
Oh, I mean, I think that we've now seen decisions from the current court, which has changed since these decisions, that suggest it's not clear what the future holds, but that certainly a big change since the Warren Court of '65. Cases like Whole Women's Health, cases like Hobby Lobby, which I think we'll talk about in a moment if we have time, that suggest the court is wrestling still with the issues of contraceptives. Do employers have to subsidize contraceptives for their employees under the Affordable Care Act if they have certain religious beliefs? No. Can a state decimate a reproductive health infrastructure without any health reason and placing undue burdens on people in that state? Whole Women's Health? No. So it's a complicated picture.
I think even more fundamentally, the court is still fighting over how do you find a non-textual constitutional right. And some of the language that we saw in both the majority and the dissent in Griswold is still banging around. All these years later, that fight is as hot as it was then.
And we'll end on that note in just a few minutes. Pat McKee Richards on Facebook makes the 10th Amendment argument that says that the court doesn't have the right to do this. If you read it, it says that the federal government needs to defer to the states for all things not enumerated.
Well, I think that is almost akin to the 9th Amendment argument that the court should protect people's interests, that people retain rights not explicitly mentioned in the Constitution, an argument that Justice Goldberg was trying to make in his concurrence. And that argument also hasn't had much in the way of legs. And I think it's because to suggest that states have all the power, courts have all the power, is to get wrong what our balance of power should be between courts and between state legislatures, between the federal government. We have a separation of powers that keep any one entity in check, and that's an important part of our democracy.
I agree with Rachel that argument has not had legs. I think here's as far as I think the court might be pushed. At some point, you might have a majority of justices that say, show me the history and tradition where this right is embraced by the country. And other justices will say, no, we can name broader, evolving concepts of justice, a living constitution notion. But I've never seen the 10th Amendment argument get legs.
Next is a caller watching us in Arlington, Virginia. Stadius, you're on.
Hello. I was thinking with the eventual retirement of Justice Kennedy and the rise of mainstream opinions by Justice Thomas, do we see a reduction in the substantive due process argument when it comes down to protecting privacy rights?
Potentially. It's hard to know. It is hard to know. There are strong precedents now that support the substantive due process approach to the right to privacy. To untangle, to disregard all of them would be a huge sea change at this point. I don't think it's as easily undone as we suspect it could be just by the retirement of one justice. Now, would it shape future cases' interpretation, the court's future interpretation of substantive due process protections? Undoubtedly. We see that with appointments. But revolutionize substantive due process doctrine, I think that would take more time.
Well, a good time to play our last clip for this. The Griswold decision is one of the most frequently asked about cases for potential Supreme Court justices when they're going through the Senate confirmation process. Let's show you a clip from the most recent one. Neil Gorsuch, when asked about this case during his confirmation hearing in 2017.
Griswold, Senator, as you know, held that the 14th Amendment due process liberty clause provided a right to married couples to the use of contraceptive devices in the privacy of their own home. And then Eisenstadt extended that to single persons.
Right.
Senator, those are precedents in the United States Supreme Court. They've been settled for 50 years, nearly, in the case of Griswold. There are reliance interests that are obvious. They've been reaffirmed many times. I do not see a realistic possibility that a state would pass a law attempting to undo that, or that a court of the United States would take such a challenge seriously.
So when you hear him frame it in that particular way, what are you hearing?
Well, first, I'm shocked that he misstated the holding of Griswold. He said it located the right in the 14th Amendment Liberty Clause, and it did not. The dissents did, but the majority did not. Second, he's dodging, I hate to use that really blatant word, the question, do you think what the court did was correct, by stating what is probably undoubtedly correct. You're not going to see this kind of law again, so please don't worry about it. It's never going to come to me.
What did you hear?
I heard the same, and I also heard that our obsession in some ways with the holding of Griswold as being either, is there a right to privacy, is there not, is it enumerated, is it not enumerated? You know, in some ways it misses an interesting conversation about what's limiting about the decision in other ways. That a right to privacy doesn't guarantee any individual the right to gain access to those services. It doesn't fund public or private clinics at a higher rate. It doesn't, it doesn't speak to equality in the ways that we've discussed. And so I found his answer, my reaction is, that's what I'd expect a Supreme Court justice nominee to say.
Because it leaves the door open for other cases to come, which are outside that very narrow framework that you described. Paul is in White River Junction, probably going to be our last caller tonight. You're on the air. Welcome.
Hi, I grew up in New Haven. I remember at 16 years old driving by that Planned Parenthood Center, and they had religious women. Well, I don't know if they weren't nuns, but they were people performing a prayer service of on their knees on the sidewalk, and I wondered if that it was 24 hours a day for weeks. I wonder if that affected the case positively or negatively.
From a historical perspective, when you do teach about this, what do you tell your students about these societal frameworks for the decision?
I usually talk about the technology of the pill and what a gigantic cultural moment that was. I usually talk about picking your plaintiffs as a married couple. There were still lots of laws on the books in those days that forbade cohabitation, adultery, non-marital sex. So, the pill came into, and the Griswold case came into a pretty conservative country on sex. And so I didn't know about the protesters or the prayers outside the clinic. I usually talk more about the pill and the technological and cultural moment.
And what do you tell your students?
I often teach Griswold as part of a family law course, and so I tell my students a little bit about the parenting cases, the sterilization cases that came before Griswold that helped convince the justices in Griswold that there was a fundamental right to privacy. And I do that because I think it gives a background to the ways in which we thought about parenting, marital, intimate relationships as something that needed a closer look, that helps make sense of some of the cases to come. And what are the limits to that right? That there are state interests, as I think as Helen mentioned, fortification laws, adultery laws. Those were constitutional laws. Those laws still exist in states. So, they don't exist in the number that they had in the past, but states still have a considerable amount of leeway in protecting the health, safety, morals of its population.
There are about a dozen state constitutions and many, many statutes around the country that do speak explicitly to the right of privacy. But it sounds like, from what Rachel just said, that there are going to be continual challenges to what the interpretations of those mean.
Yeah. In fact, one of my students say when they've taken Griswold and the cases that came after it, they say, I didn't know this was a constitutional law class. I thought this was family law. And I say, we are going to follow this fight over what is substantive due process and the rights that the Liberty Clause of the 14th Amendment provides. We're going to follow it right up to today. And Griswold is the place where you first get the interesting roiling in the family law context.
That's a great place to leave it. Thanks to both of you for being at our table tonight. Thank you to the National Constitution Center as we close here. Reminder, we've got many more cases to go. There's 12 in the series. We have a booklet that we've put together that has a synopsis for each one of the cases. You can find it on our website at cspan.org, landmark cases, if you'd like to learn more about the background before we get to the table over the next few weeks. Thanks for being with us tonight.